right, so here we go. Okay, so number one, Mark, a licensed broker, procures a ready, willing, and able buyer for the seller principal. The seller accepts the buyer's offer in writing and then experiences a change of heart and withdraws the acceptance. In this situation, Mark is entitled to collect a commission, is without recourse because the transaction was never completed, may sue the buyer, may retain the deposit as a commission. All right, so we have A or B as the okay, and I've got the wrong answers. So mine is Mark is a licensed broker. Okay, so then in that case, my answer is B. Okay, I don't have the answers. Here we go again. The answer is B because the transaction didn't go forward. All they did was accept it. All right. Again, yes, in this situation, the question mark is, are they out of attorney review or are they not out of attorney review? That in itself would also make a decision whether he can collect a commission. All right. So my answer to that is he can collect a commission or go after a commission if they are out of attorney review, because then they are officially under contract. All right. If it was just an acceptance, just accepted, signed, and they were going into attorney review, then my answer would be no, that they're not entitled. Then they're not entitled because they're not officially under contract. All right, so that would be my answer. Okay. All right, number two, a real estate company has entered into agency agreements with both a seller and a buyer. The buyer is interested in making an offer on the seller's property. Can this occur? A, no, because the real estate company would then be a dual agent. B, yes, as long as written agency agreements have been entered into with both parties. C, yes, if the seller has agreed to pay the commission. And D, yes, if the buyer and seller both give their consent to dual agency. All right, and the answer is yes, if the buyer and seller both gave their consent to dual agency. Ding, 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 ding to all the D's. Okay, next, number three. A seller's listing agreement has expired and the seller lists with a different brokerage firm. Jim, the original listing agent, now has a buyer interested in the seller's property. Based on this information, Jim is a dual agent. Jim cannot disclose to the buyer offers received on the seller's property while it was listed with him. Jim cannot disclose to the buyer information about the physical condition of the property, or Jim cannot represent the buyer. Ding, 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 cannot disclose to the buyer offers received on the seller's property while they were listed with him. B's have it. Ding, 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 ding. Okay, number four. A real estate salesperson has been working with buyers. After helping them negotiate for their dream home, the buyers asked the salesperson if she could help them secure a mortgage. The salesperson knows a lender that pays a fee for referring purchasers to it. Should the salesperson refer the buyers to the lender? A, no, because this would be an unwise referral. B, yes, if the salesperson and the buyers have previously entered into a written buyer agency agreement. C, yes, if the salesperson discloses the referral fee to the seller. And D, yes, if the lender offers the market's best interest rate and terms. Oh, thank you, Zachary. Thank you, Allison. All right, so the correct answer is no. This would be unwise referral. Are we allowed to get paid by other people? Okay, would this be considered a kickback? Yes. So the answer is A, no, because this is an unwise referral. Okay, number 5. A buyer contacts a real estate office and indicates an interest in purchasing a home in the area. Without entering into a buyer agency relationship with the buyer, a salesperson from the real estate office can do all of the following except A, provide the buyer with information on properties for sale in the area, B, give the buyer information on mortgage interest rates and terms, C, pre-qualify the buyer for a mortgage, and D, explain to the buyer about buyer agency, seller agency, and dual disclosed agency. Okay, ding, 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 ding. The C's have it. So they cannot pre-qualify the buyer for a mortgage.
Gloria,
Yes,
B is also correct. B
B,
is also correct. You have to be a licensed mortgage broker to give out interest rates and terms. Like, you know, just like with the agents, with the people that work in the office that are unlicensed, they're not allowed to talk about homes. No one
correct.
can talk about interest rates and terms. So
No,
that's a kind of a,
it is a
but if you
tricky
have,
question. It is a tricky question, but here they're talking about pre-qualifying. That's where the correct.
yeah, so if you have to pick, that one's more important. Yeah, I see that.
Exactly, right? Yeah, you have to pick your battle as to which is
Right.
more correct. That doesn't mean
Mhm.
that there aren't any other correct answers. Which one specifically answers the question? And in this case,
Yeah, no, I see it.
all right, and that's how some of the questions are in the state exam. You are going to have to choose which is more correct for the question. Now, that answer in another question, that answer may not be 100% correct answer, but it is the 100% correct answer for the question. All right, so you are going to find that in the state exam. So while you know that the 100% correct answer is blah, 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 but this 100% correct answer is not answering the question. And so therefore you'll have to pick an answer that may not be 100% correct, but it will be correct for the question the way they worded it. All right, am I making myself clear on that? And this would be
Yes.
and this would be a perfect example right here. All right, so number 6, a buyer prospect is interested in seeing a house listed with the real estate company, but does not wish to enter into a buyer agency agreement. A salesperson from this real estate company can show the buyer an in-house listing if the salesperson obtains the seller's permission, B, the buyer verbally agrees to buyer agency, C, salesperson provides the buyer with agency disclosure that the real estate company represents the seller, and D, the salesperson provides the buyer with a dual agency consent form. All right, so, okay. So Eric, the answer that you have, is it to number 6? Okay. Okay, all right. I think somehow I need to, okay, 5 is A, okay. So 6 is A, huh? Okay. All right, so we have D's and A's. Okay, hope so. The answer is incorrect. All right, the answer is the salesperson provides the buyer with an agency disclosure. CIS is the answer, that the real estate company represents the seller. All right, so basically what they are referring to is the consumer information statement. All right, so again, the buyer prospect is interested in seeing a house that's listed with the real estate company, right? What are we at that point?
In a dual agency?
We're in dual agency, Zara. Yes, that is correct, right? So the answer is C is the correct answer because we need to explain to them agency, do we not?
Yes.
Yes. And in discussing consumer information statement, are we not at that point also talking to them about dual agency plus that we represent the seller? All right, so the C is the correct answer. All right, because here we're talking about the disclosure that the listed property, if I'm representing you as the buyer, at this point, the brokerage company is representing the seller. I may be representing you as the buyer, and therefore you also have to understand that we will be in disclosed dual agency. All right, the person does not have to give a dual agency consent form, not until a contract offer is presented. That would be the only time that the buyer will be signing that document. Okay, in New Jersey, an exclusive right to buy contract is illegal, is equivalent to a listing agreement, must be indicated as such in the buyer agency agreement, or requires the signature of the principal only. All right. So people who didn't know took a really good guess, and C's have it. The answer is it must be indicated as a such in the buyer agency agreement. Okay. Yes, it's worded differently, but basically they're saying that they are going to be represented as in a buyer's agency agreement. All right. Number 8, buyer brokerage contracts in New Jersey must be in writing to be enforceable, must be on specific forms, are not regulated under the license laws, or are illegal. Ding, 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 ding. A is the correct answer. Must be in writing to be enforceable. Good job, guys. Good job. All right, number 9. All of the following provisions are included in the New Jersey Real Estate Commission rules regarding listing agreements, except that a listing agreement must state the exact fee the broker will earn. B, a listing agreement must be accompanied by a qualified expert's report of the property condition. C, a listing agreement must be in writing and signed by both the broker and seller. D, the seller must receive a true copy of the listing agreement after signing it. Good job, guys. Great job. Bravo, bravo. B is the correct answer, except a listing agreement must be accompanied by a qualified expert's report of property condition. That is not true. Number 10, what are the 3 types of agency recognized in New Jersey? A, seller, buyer, undisclosed dual agency. B, subagency, disclosed dual agency, seller. C, seller, buyer, disclosed dual agency. D, seller, buyer, full fiduciary. Ding, 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 ding. The C's got it. Seller, buyer, disclosed dual agency. Way to go. All right. At number 11. In a dual agency situation, a broker may collect a commission from both the seller and the buyer if the broker holds a state license. B, the buyer and the seller are related by blood or marriage. C, both parties give their informed consent to the dual compensation. Or D, both parties are represented by the attorney. All right, and the C's have it again. Both parties give their informed consent to the dual compensation. All right, ding, 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 ding. Great job, guys. Great job. High five. All right, number 12. A buyer is interested in seeing a house with XYZ Realty, but does not wish to enter into an agency relationship. A salesperson from LMN Realty can show the buyer the house if A, XYZ Realty obtains the seller's written consent to subagency, and the buyer is given an agency disclosure notice stating that LMN can represent the seller, or B, XYZ Realty obtains LMN Realty's consent to subagency, Jesus, and the buyer is given an agency disclosure notice stating that XYZ represents the seller, or C, the buyer verbally agrees to buyer agency, or D, this cannot occur. Great job. Great job. The answer is A. Okay, because again, we're talking about subagency, right? Now, we don't have it nowadays, but they might ask a similar question in the state exam because they are still talking about subagency. All right, so great job on that. Number 13. Okay, number 13. Now, again, alternatively, I just want to read the answer. I know you got it correct, but I just want you to know the explanation. If the seller gives permission for subagency, the agent can show the seller's listing. The buyer has indicated that the buyer does not desire representation, so therefore LMN Realty can also function as a transaction broker, because a transaction broker, does that transaction broker have a fiduciary responsibility? No, exactly. A transaction broker has no responsibilities, no representation. So in that case, a transaction broker would work perfectly in this situation. Okay, number 13. In New Jersey, when a broker is listing a home and asks the seller to complete a property condition disclosure, which of the following statements are true? A, the disclosures are optional and the seller may avoid liability by refusing to make any disclosures about the condition of the property. B, the standard disclosures cover a narrow range of structural conditions only. C, an agent should not give the seller any advice regarding which property conditions to disclose and which to ignore. And D, property condition disclosure is required by New Jersey statute. Oh my. I hate to disappoint all of you, but it is not a New Jersey statute. All right, so D is not the correct answer. Okay. All right, so the correct answer is A. Okay, a property condition disclosure is not required by New Jersey statute. Disclosures are optional. However, a written disclosure is wise and prudent and may protect both the seller and the agent from liability. So A is the correct answer. All right. Do brokers want the seller's disclosure? Absolutely. Do I want a seller's disclosure? I'll tell you why I want a seller's disclosure. I want a seller's disclosure because I want that first, again, I'm always dealing with a first-time home buyer. I want that first-time home buyer to know what the seller has done to the property, so that when that first-time home buyer is looking at a seller's disclosure, they'll see, oh, they replaced the furnace. Oh, the water heater is 10 years old. Ooh, maybe in a year I might have to replace that. Oh, they did work on the kitchen. I don't have to worry about the kitchen. Oh, we've got new refrigerator, new this, new that. Oh, they fixed this, they fixed that. So the only thing as a new first-time home buyer, I will just need to worry about the water heater. All right. Am I making sense regarding that? Is that helping you to understand why we want the seller's disclosure? Okay. That's the reason. It's not a statute. Okay, but the reason is because we want everybody to know, and again, it doesn't have to apply to a first-time home buyer, but that's what I use as the example to talk to the seller. This way, it allows the people to budget and figure out what they're going to have to worry in the first year that they're living there. On the other hand, I might also suggest or recommend that the seller get a home warranty, so that this way, this will give additional protection or comfort to the buyer that that first year, all they have to worry about is just paying a service charge, and the home warranty is going to cover any kind of major issues on any appliance or furnace or anything like that. All right, so number 14. A salesperson represents a seller in a transaction. When the prospective buyer asks to look at the property, the salesperson must A, tell them that they must first enter into a buyer representation agreement with another licensee. B, inform them in writing that the salesperson represents the seller's interest. C, inform them either orally or in writing that the salesperson represents the seller's interest. Or D, show them the property without making any disclosures about the salesperson's relationship with the seller, because such disclosure would be a violation of the salesperson's fiduciary duties. So number 14. Okay, so again, we have a choice. We have C, okay, and we have B. All right, and so the answer to this question, the answer that they're using is B. Okay, the agent must disclose in writing that the agent represents the seller. Buyers do not have to be represented to work with the seller's agent, and the disclosure must be made so that the buyer understands that he or she is not being represented. Okay, so B or C would have been our correct answers. All right, but based on this particular, based on this test, the answer is you have to put it in writing. And again, the in writing, what is it going to be? It's going to be the CIS form. Would that not be a fair statement? Okay, all right, because understand that just this is just you and me talking, right? So understand that a lot of times the buyers feel that they are going to get a better deal by dealing with the listing agent. What they don't understand, truly don't understand, that they are truly not being represented at all when it comes to negotiating the offer that they might want to represent, or that they might want to offer, all right, present to the seller. So you need to let them understand that. And again, the easiest way is by doing it with the CIS. So again, if it's a phone call, you might want to send them a PDF and say, look, I'm just sending you about representation. I want you to understand it, and then go from there. Again, a lot of times people are, and I'm going to use the word ignorant, or they just don't want to know. All they want to know is, I want to see the house. I want to make sure that this is my house and it's in my price range and all of that. And a lot of times they just basically ignore everything else. But we can't ignore that, because again, we don't know if this is a tester or a checker, right? So we're going to do everything to protect ourselves and to protect our license. Okay, so number 15, 5 years ago, unit 5B in a condominium community was the site of a brutal and highly publicized murder. The unit was sold to an elderly woman who contracted AIDS virus in a blood transfusion and then died last year. Died in the unit last year. As the agent for the woman's estate, what are your disclosure responsibilities to prospective purchasers of the unit? A, you must disclose both the murder and the AIDS-related death. B, you are specifically prohibited by law from disclosing either event. C, in New Jersey, you are not required by law to disclose either event. And D, you do not need to disclose the murder, but you must disclose the AIDS-related death. Good job, everybody. C is the correct answer. All right. Now, if I, the buyer, specifically ask you, did somebody die in this unit? Do you have to answer that question? Yes, if known, but you don't need to go into the details. All right. So if I ask you, did somebody die in this unit? You just say, yes, I was told by the estate that this woman died in the house. All right. And a lot of times it would be an ethnic situation, an ethnic question, because again, I'm not here to discriminate, but typically Chinese people ask that because they don't want to buy a house where somebody died in, and specifically died in the house. Not that they died, but died in the house. And the same thing with Indian people. They don't want to buy houses again also where somebody passed away in the house. All right, so number 16. So you guys are doing good. Look at you guys. All right, a broker took a listing for a small office building. Because the property is in excellent condition and produces a good steady income, the broker salesperson has decided to purchase it as an investment. If the broker salesperson wishes to buy this property, the salesperson must A, resign as the broker's agent and make an offer after the owner has retained another broker. B, have some third party purchase the property on the salesperson's behalf so that the owner does not learn the true identity of the purchaser. C, obtain permission from the New Jersey Real Estate Commission. Or D, inform the owner in writing that the salesperson is a licensee before making an offer. Ding, 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 ding. D is the correct answer. Inform the owner in writing that they are a licensee. Very good. All right, 17. 6 months after a buyer bought a house, the roof leaked during a rainstorm. When the house was listed, the seller told the broker that the roof leaked, but they agreed not to tell any prospective buyer. The broker claims that the buyer did not ask about the roof. So under these facts, the buyer, A, can sue the broker for non-disclosure because disclosure is required by licensed law. B, the buyer cannot sue the broker under licensed law. C, the buyer can sue the seller under the licensed law. And D, the buyer cannot do anything because the leaking roof could have been discovered by inspection. Okay, anybody else? All right, so the A's have it. Ding, 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 ding. The broker can be sued for non-disclosure because the broker was told about the roof leaking. And if you're told about that, you have to disclose it. All right, so that A is the correct answer. Okay, number 18. A real estate licensee must give the agency disclosure statement to prospective purchasers' tenants, A, at the first face-to-face meeting before they're shown any properties, B, at the request of the purchaser tenant, C, at the closing table, D, before any offers to purchase or lease are presented or prepared. Okay, so in this case, everybody's wrong, except for Zara, who chose A. The answer is in this kind of an answer, the answer is first face-to-face meeting. All right, because you see, you should have trusted your gut because, all right, it doesn't say letter D, it doesn't say before any financial statements or motivation. It's just talking about an offer to purchase presented. All right. It's not talking about discussion or motivation. So the answer to that then would be in this case, A. All right. So at least you know you got it right. You just didn't trust your gut, Zachary. That's all. That's good. That's good. You recognize that. All right. So great job. Okay, 19. A real estate licensee has signed a brokerage agreement with the tenant who is looking for an apartment to rent. The licensee does not charge a fee to prospective tenants. Rather, the licensee receives the commission from the landlord. The licensee tells the landlord that the prospective tenant could probably pay a somewhat higher rent than the landlord is asking. So which statement is true? A, the licensee owes the statutory agency duties to the landlord who pays the commission. B, the licensee disclosure to the landlord was appropriate under these circumstances. C, the licensee disclosure violated the confidentiality duties owed to the tenant. And D, the licensee is not charging a fee to the tenants. The licensee has violated New Jersey law. Ding, 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 ding. You guys got it good. C is the correct answer. They violated the confidentiality duties owed to the tenant. All right. Number 20. You guys are getting good at this. You should be proud of yourselves. Great job. Maria, a licensed salesperson, obtains a listing. Several days later, the salesperson meets prospective buyers at the property and tells them, I am the listing agent for this property, so I'm very familiar with it. Under these circumstances, A, Maria has failed to properly disclose her agency relationship. B, Maria has properly disclosed her agency relationship with the seller. C, Maria is in violation of New Jersey Real Estate Commission regulations because the listing belongs to the broker. And D, Maria has created dual agency, which is a violation of New Jersey Real Estate Commission rules. All right. All right, so the correct answer is A. All right, and has failed to properly disclose her agency relationship. All right, that is number 20. That is the correct answer. It was not sufficient disclosure. All right, number 21.
Gloria, I have a question about that.
Sure.
What would they have to additionally disclose for that to be enough?
The CIS. Right? In this case here, is she not the listing agent? This Maria, right? Does that mean by her meeting with the buyers, what does that make her? Who is she really representing? Right, Marissa, that is correct. Dual agent. Absolutely. Right? So just because she's a listing agent, she's meeting with the buyers. What did she create? She created dual agency. So she has to let the buyers know up front that they are not being represented. And it needs to be disclosed to be legal. Otherwise, what she's doing is illegal. It's undisclosed dual agency. And you're correct, Marissa, she has to disclose that it's dual agency, otherwise it's illegal. It's at that point, she's undisclosed dual agent, right? She's meeting with the buyer. And she just says, I'm the listing agent. Does the buyer know that she's representing the seller? And in this event, may be representing them also? So that's undisclosed dual agency. Did that answer your question? Good. All right, good. All right, 21. A real estate broker representing a seller knows that the property has a cracked foundation and that its former owner committed suicide in the kitchen. The broker must disclose A, both facts, B, the suicide but not the foundation, C, the cracked foundation, but disclosing the suicide could constitute a breach of duty to the client, or D, neither fact. C is the correct answer. Ding, 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 ding. So cracked foundation, yes. All right. And disclosing suicide is a breach. All right, 22. A broker has entered into a listing agreement with the seller. Another broker who is working with the buyer learns of the property through the MLS. Typically, the second cooperating broker would represent A, the seller as a sub-agent, B, the buyer as an agent, C, the buyer as a sub-agent, and D, neither the buyer nor the seller. Ding, 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 the bees have it. All right, the buyer as an agent. All right, that is the correct answer. Okay, 23. When a broker represents a seller of real estate, an agency disclosure must be given to the A, seller at the beginning of the first personal meeting with the seller concerning the real estate. B, the seller at the time the listing agreement is signed. C, the purchaser before the purchase and sale contract is signed. Or D, purchaser at the beginning of the first personal meeting with the purchaser. It's a trick question. Anybody else? Because this is a trick question. All right, so the person that got it correct is Dennis and Karen. Ding, 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 ding. D. All right, we need to disclose to the purchaser who we are representing. And so that would be at the beginning of the first personal meeting with the purchaser. And that was the trick question. All right. So the answer that they've given us here is the buyer needs to be aware of agency representation, and the agency disclosure must be made at the beginning of the first personal meeting with the purchaser. All right, because again, the question here is when a broker represents a seller, we already know that they're representing the seller. So it's not like they're going after a listing. They've already got that. All right. Oh no, disclosure is needed to the seller, but the statement is that they're already representing the seller. That's what that statement is saying. So they would have done all of their disclosure with the seller a while back. Am I making sense?
Yeah, that's why I went with D, because of what you just said, because the relationship is already there as the selling agent, so the disclosure was already made.
Right. Ding, 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 ding. You got that correct. That is the trick question. That is, the representation is already there. They're not saying that they're going to the seller. All right. Yes, exactly. Right. 23, because the word here is, this is the word. This is the trick word. This is what that's why I say when there's one word that's going to change the sentence. All right. Here's the word that changed the sentence. The broker represents a seller. That's it right there. So if they're already representing the seller, what's the next thing? We might be meeting with the buyer. And at that point, what are we going to have to do? We're going to have to let them know about agency relationship. Okay. What documents should be an agency disclosure? Well, what document do we say has to be done at the first meeting? CIS, ding, 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 ding. Right? That's the document that's talking about agency. Right? So that's the document that no matter what, that's what you're going to have to give and explain. All right, number 24. The realty company has entered into agency agreements with both the seller and the buyer. The seller and the buyer have signed dual agency consent agreements, and the salesperson with realty company has been working with the buyer. Legally, the salesperson may A, provide comparable market data to the seller after the buyer requests and receives such data from the salesperson. B, disclose to the seller the buyer's financial qualification. C, disclose to the buyer that the seller will accept less than the listing price. Or D, disclose to the seller that the buyer will pay more than the offer. All right. Okay, so for those of you that have chosen B, okay, in the question, it states we have dual agency. So is B illegal based on dual agency? Yes. All right. So again, here's the word that changed the whole question, right? So the answer is the ones that have chosen A, that is the correct answer because nothing else would answer that question. And this is true. When you are representing, let's just say you are lucky that you get both sides of the deal, right? So you have the listing and you now have the buyer. The answer is that if the buyer requests a CMA, then you are going to have to do the CMA for the buyer and send that same CMA to the seller, because both parties have to have the same information, right? You have to treat them equally. So if one asks for particular information, then you have to give that same information to the other side. Now, again, I'm not talking about qualifications or prices or anything like that. For the buyer to make a proper decision on putting an offer in, then the seller also has to see what's making that buyer come up with that decision. Yes, because you are representing both parties. Exactly that. All right. So again, another trick question, another item you need to know about representation in dual agency. All right. But like I said, you guys are doing good, except that one exception where you didn't listen to yourself, but that's okay. You know you didn't listen to yourself. All right, number 25. A broker decides to sweeten an MLS listing for a property by making a blanket offer of sub-agency. Is the broker's action acceptable? So A, yes, because New Jersey law permits the creation of sub-agency relationships only through multiple listing services. B, yes, because the sub-agency relationship may be created by either a blanket offer in an MLS or through specific agreements between the parties. C, no, because sub-agency is illegal under the New Jersey Real Estate License Act. And D, no, because sub-agency relationships in New Jersey may be created only by a specific agreement between the parties. So that's a very difficult question. So I'll let you guys read it. Oh, you already made your choices. All right, well, the correct choices are D, ding, 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 ding. All right. It can only be agreed to by a specific agreement between the parties. So ding, 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 ding. Good job. All right, number 26. Are you guys feeling better today? Come on, admit it. Ah, I can see it. Good. And I can see by the answers. So bravo, congratulations. All right, you guys are doing good. Oh, that's okay, Stephanie. You'll start feeling better after the break. All right, trick questions, yes. And that's why I like this test, because it's got tons of them. All right, so number 26. A brokerage relationship with a buyer or seller as agent, non-agent, or disclosed dual agent must be determined and all necessary agreements executed. A, at any time after a purchase and sale agreement is executed by the parties. B, at the time of the first substantial business contact. C, no later than the time a purchase and sale agreement prepared, or D, no later than the closing. Ding, 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 ding. That is the correct answer. All right, at the time of the first substantial contact. All right, 27. A broker's buyer client wants to purchase a house that the broker has listed for sale. Which of the following statements is true? A, if the listing salesperson and selling salesperson are two different people, there is no problem. B, the broker should refer the buyer to another broker to negotiate the sale. C, the seller and buyer must be informed of the situation and agree the broker represents both of them. And D, the buyer should not have been shown a house listed by the broker. And C is the correct answer. They should both be informed of the situation that they're in dual agency. All right, 28. The Consumer Protection Law requires that the broker keep confidential all information that the seller has provided. B, the broker disclose everything that the seller tells him or her. C, the broker discloses information that might affect the sale, even though the buyer does not ask for it. Or D, the seller discloses all facts that might affect the sale. Yes, tough choice. So go, Marissa, go with your gut. And then you'll see if your gut is right. And then you'll learn from that. Oh, all right. So the correct answer, you should get some Maalox. Or Gaviscon. The correct answer is C. All right. The broker disclose information that might affect the sale, even though the buyer does not ask for it. All right. Again, think of it is the information that you have been given or that you know. All right. May not be something that you've been given, but you may have just found something out. Let's use that as an example. You just found something out and it has not been put into writing. But this finding out, let's just say we found out that the furnace isn't working, right? You were showing the house, you wanted to turn on the hot water. Let me use that as an example. The hot water isn't working. The seller doesn't know about this yet, but you know about it because you're at the house. You're turning on the hot water because you want to show that it's working and everything. And lo and behold, there's no hot water. And so you are then saying, okay, I just want you to know, I just found out about it because I turned on the hot water faucet. It's not working. Will that affect the decision of the buyer, whether they want to buy that house or not? Yes, it will affect their decision because it may mean A, that the seller may not fix it. All right, I didn't give you any further information, but that's one choice. And B, the buyer doesn't want to pay for that. All right, so would that affect the decision? The answer is yes. Okay, So that's the answer to that question. All right. So now I got a question for you, Marissa. Was D your first answer? Ah, there you go. So you knew the answer. Okay, good. All right. You just second guessed yourself, but now you know better, right? Okay. Number 29. In New Jersey, the real estate license law is administered by A, New Jersey Department of Banking and Insurance, B, New Jersey Real Estate Commission, C, New Jersey Association of Realtors, or D, Department of Housing and Urban Development. Okay, I suggest some of you might want to reread the question. All right, so is this everybody's final answer? All right, so the B's have it. What does the Real Estate Commission do? It administers all the laws along with their own law. Right? Thank you, Karen. That is correct. Is the New Jersey Real Estate Commission part of the Department of Banking and Insurance? Yes, but it's the Real Estate Commission that administers everything. All right. Do they collect the money? No. Thank you. Ding, 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 ding. All right, good. All right, number 30. How are members of the New Jersey Real Estate Commission selected? By the governor, by public election, by the state association, or by licensees? Ding, 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 ding. A is the correct answer. The Real Estate Commission has authority to make and enforce the rules by which all licensees must abide. They have the authority to compose the examination questions on the state exam. They have the authority to administer the exams given at the testing sites, or they have the authority to enact the laws that govern real estate licensees. All right, and everybody who did A is correct. Ding, 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 ding. They make and enforce the rules by which all licensees must abide. They are also considered a quasi-judicial body of the law. All right, so what does that mean? That means that if they need to make up a law because there's something missing there, the answer is they can make up a law because there's something missing there, because they have that legal right to do that, because they are a quasi-judicial body. As long as it's not illegal or goes against an already set up New Jersey law, all right, they can make up a law to take care of something that's missing. All right, so that's an important factor. Okay, the Real Estate Commission may undertake an investigation of a licensee based on all the following grounds except, all right, A, its own initiative, B, a random selection of licensees, C, a motion from the members of the commission, or D, a written complaint submitted by a disgruntled customer. Good job. Anybody else? Awesome job. Bravo, bravo. High five, everybody. High five. All right. The answer is they cannot do a random selection of licensees. All right. But they can do their own initiative. It could be a motion by the commissioners, and it could be based on a complaint from a disgruntled customer. All right. All right. Number 33. In New Jersey, a real estate license is required for which of the following? A, person who employs fewer than 3 apartment leasing agents. B, licensed attorney acting under a power of attorney to convey real estate. C, a resident apartment manager working for an owner if the manager's primary residence is the apartment building being managed. And D, partnership selling a building owned by the partners. All right. Who needs a license? Yes, this is a tricky question. So do read it. And we may not have gone over it because it's not one of the things that we that's in the book, but it's good to know. All right, so I will tell you, read D. Those have chosen D. I'll read it to you again. Partnerships selling a building owned by the partners. Would that be a for sale by owner? Okay, so not D. Okay. Okay, so if the lawyer is just conveying, he's just passing titles, so he's not involved in an actual transaction. Or if he has a power of attorney signing on behalf of the client, again, you are correct, Eric, he's just conveying. So you are correct, B is not the answer. All right, so that's good. So now we have a choice of C or A. And I think we have a 50-50 answer on C and A. So I will read you the correct answer. The correct answer is A. Okay. And as I said, we did not discuss it. So you should have gotten it just from that answer that I gave you. All right. So here, A. Anyone holding a power of attorney has the authority to sign the principal's name and does not have to have a real estate license. Oh, don't jump off the cliff. It's not worth it. All right. Anyone who employs a resident manager is specifically exempt from licensing requirements. Okay. And partners selling their own property are not required to have a real estate license. So the only correct answer, whether it's true or not true, well, in this case it is, but the answer in this case is A. All right. A person who employs fewer than 3 apartment leasing agents will need to have a license. All right. And more specifically, if we're talking about leasing agents, then in this case here, this company, why isn't C correct? Because the answer is, again, we didn't go over this because it wasn't part of our book. But the answer is anyone who employs a resident manager, meaning that they are living there, all right, is specifically exempt from licensing requirements. That's the actual answer. So if you are a manager living in a complex, in an apartment complex, you do not have to, then you would. Yes, that is correct. Yes, if the manager is not a resident of the property, then they're going to need either a property manager or a license. Yes, and where I was heading to, the one up above here, is that if the person is employing 3 apartment leasing agents, then that means it's a I was heading to that they're a property manager, right? And a property manager has to be a broker and has to hire licensees underneath them. All right, so we're back to that. And a property manager will must have a broker's license. All right, so look at that. We're learning even more stuff than what the book has. And again, you never know what's going to pop up, so it's always good to have a little bit of extra knowledge. All right, number 34. Which of the following requires a real estate license? A resident manager who collects rent on behalf of a building owner, company that for a fee, not a commission, matches individuals from different parts of the country who want to exchange properties and assists them to do so. A C, not-for-profit real estate referral service. And D, executor selling a decedent's property. Okay, so we are not doing good on this. What is the statement in the book? And this is something you should know. All right, so you should be getting this correctly. Oh, okay, we got 1, 2. Okay, 2. All right. What does it state in order for you to have a license? If you are getting a fee, do you need to have a license? Okay, Zara, you had it right. All right, so the answer is B. A company that for a fee, even though they say it's not a commission, it's still a fee. Are they getting something for matching people to real estate? That's really what the answer is. Is the company getting monies for matching people for real estate? And the answer is yes. So therefore, B, they need to have a license. Right? And doesn't that tell us that in chapter 1 at the very beginning? All right, let's go back. That's basic chapter 1. All right, so let's go back just to make sure that I got it right. All right. No, they're not going to give it a payment here. Payment services. To collect a commission, one must be licensed. It's as simple as that. Commission, fee, whatever word, compensation. Okay, Zachary, there. Well, okay, so page 3, somebody told me, good, thank you very much. So whenever there's compensation, you have to have, yes, if you're getting compensated for helping somebody with real estate, let's phrase it that way. If you are getting compensated for helping somebody do real estate, then the answer is you need a license. So the one question that I had, or the one example that I had, if a mom was asking her son to help her sell the property and she was going to give him a brand new Mustang, does he have to have a license? Yes, Because was he compensated for helping her to sell a real estate? Yes. How was he compensated? He got a Mustang. Does a Mustang have value? The answer is yes. Therefore, it's compensation. All right, so we'll do 35 and then we'll take a break. Number 35. So under New Jersey law, any person who acts as a real property securities dealer must be licensed as a real estate broker, must have his or her securities license endorsed by the Real Estate Commission, must be approved by the Securities Exchange Commission, or there are no special licensing requirements for real property securities dealers. Okay, so I don't know the answer, but here is the answer. They must be a real estate broker. Under New Jersey law, any person who acts as a real property securities dealer must be licensed as a real estate broker. So A is the correct answer. I did not know that. Okay, but I also do know that if we're dealing with securities, they have to have a securities license. So I'm really betwixt A and B, but based on this answer sheet, it's in this case here, it's A. All right, but me personally,
Gloria,
Ed,
I'm sorry. I have a question.
on. I think we just lost you. Okay. Oh, yeah, you're coming back on.
I'm sorry, I got kicked off. I don't ever remember hearing about a securities dealer.
No, I am not either. But securities license is required in selling. You are correct, Dennis. It is required in selling real estate investment trusts. All right. So I have not heard that either, and it might have changed. I don't know how old this test is. I just think it's a good test because it's got a lot of tricky questions. So I don't know if it's changed or not. But if it's going, my suggestion to you, if you do get a securities question, the answer is definitely go for the securities license or the SC, what is it, SEC, right? The Securities Exchange Commission. I would pick one of those answers. I would not have picked, me personally, I too would not have picked the real estate broker as the answer. Okay. Are we all good with that? Zoom record. Okay. So I think what I'm going to do, I think the way that we're going to do it is to go through the key terms. We'll go through the key terms. So a broker, is that somebody who owns the business? Yes. Okay, good. Are they able to sell real estate? Okay, good. Do they, can they hire other brokers, or must it be a broker salesperson? Broker salesperson, good. Ding, 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 ding. And they, of course, can hire salespeople that have licenses, right? Okay, good. How many hours of continuing education must we get? 12 hours. And the 6 hours are broken down as 1 fair housing, correct. 2 ethics, correct. 3 core, correct. And 6 elective or 6 core. That is absolutely correct. It's actually 6 electives. It's 6 and 6. All right, so 6 electives. Okay. A real estate referral company. What kind of a license hangs in that type of a company? What kind of a license hangs in a real estate referral company? No. Well, it's a real estate referral company, so obviously it's a real estate license. No offense, Alexia.
License with a referral agency.
Referral agent. Thank you very much. So it's a it's a referral license. Now, this referral license, can they do real estate transactions?
No,
No. Okay, good. So they basically can give leads and names and numbers to other people, and can they get paid? Yes, they can get paid. Okay. And do they get paid the full commission, or do they get paid a referral percentage? A referral rate, okay, a referral percentage or a referral fee. Okay, good. If they decide that they want to become a full agent where they can do the transactions, and the 2-year term passed, and now we're on to the next 2-year term, are they going to have get continuing education? Yes. Okay. And just for your own information, it will all be core subjects. So a referral agent that has hung their license, when they want to become a full licensed salesperson, their continuing education is going to be all core. Okay. So all 12 credits are going to be core continuing education. Okay, the New Jersey Real Estate Commission, part of what department is it?
New Jersey licensure and banking.
Banking and insurance, that is correct. Ding, 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 ding. Okay, does the real estate commission, does it take care of money? No. Okay, good. Are they mostly administrative? And are they the ones that make sure that make sure that the licenses are proper, the education is proper? They are also the ones that may impose fines. Good. Okay. If I have the word realtor after my name, is that a special license? Okay, so does it mean that I belong somewhere? A member of NAR, that's correct. Okay. Speaking of NAR, if we belong to NAR, must we abide by a certain rule and regulation of NAR, and what is it called? The ethics code. All right. And if somebody wants to make a complaint, if another realtor wants to make a complaint about another realtor, would they have to use the ethics code to determine what was violated by that realtor that they're complaining about? Yes, that is correct. They would have to find the article and the practice and use that to determine what was violated. Okay.
I have a question.
Yes.
Do other realtors really complain about other realtors?
Well, I will tell you that during COVID and after COVID, yes, there have been a lot of ethics complaints.
Okay.
So yes, ethics is a big deal. All right.
Okay.
And there again, like I said, I don't know what made COVID decide people to start making complaints, but the answer is as after COVID, there have been a lot of complaints and mostly ethics. When the broker is entitled to a commission for a commission in a selling process, when is the broker and is when he brings a ready. Okay, so Zara, I am presuming that entitled you mean by earned or is owed. And the answer to that is, does anybody have an answer to that?
It's owed once they bring a willing, ready, and able buyer, but it's given at closing.
Okay, well, that's not 100% correct. Anybody else? Okay, well, we're not talking about being paid. We're talking about being owed or earned a commission. That's okay. No, I'm just saying. All right, Karen, that's a good answer. It needs to be more specific. And the same thing with you, Allison, it needs to be more specific. So the correct answer is,
Review,
say that again.
out of attorney review.
Ding, 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 ding. That is the correct answer. So we are owed or earned our commission when we have brought a ready, willing, and able buyer. And the client, because it's the listing, right? The client is under contract and out of attorney review. It is at that point that we are owed or we have earned our commission. And then again, everyone is correct. We are not going to get paid until the closing, because again, there are many different aspects that can go wrong and the deal can fall apart. All right. So that is the correct answer. Okay, so now let's talk about a for sale by owner. Okay, if I am a for sale by owner, can I sell my property by myself? Yes. Okay. If I am a for sale by owner, or actually let's call it a for rent by owner, and I am going and I have a 2-family house. I am living on the one side. Can I, in quotation marks, discriminate? Because I am living there. Yes, the answer is yes, except never on race and color. All right. So if I own the property, I live there, and I want to rent out the other side as an example, and I'm not using a real estate agent or broker, and I am not advertising discriminatorily, the answer is yes, I can pick and choose who I want living next door to me, but I can never discriminate against race and color. And you're correct. It's the Civil Rights Act of 1866. You are correct, Allison. All right. The New Jersey law against discrimination, if I were to compare that to the fair housing law, which is stricter and which one must I abide by?
What was the second one?
The federal fair housing law. LAD is stricter. Ding, 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 ding. And yes, therefore, we would have to abide by New Jersey LAD law because it is stricter. So the federal fair housing law, does that pertain to commercial property, residential property? Residential, ding, 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 ding. That is the correct answer. Regarding NJ LAD, does that apply to residential, to commercial, to industrial, to land, to anything? Ding, 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 ding. That is correct.
All of it.
All property. It applies to all property. So we are not, any kind of property, real estate that we are selling, the NJ LAD applies to that. We already talked about the attorneys. Do they need to have a license if they're going to be doing a transaction, a regular closing transaction? The answer is no, that is correct. Ding, 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 ding. We stated that unlicensed assistants, can you hire an unlicensed assistant to help you?
You can hire them, but they can only do secretarial stuff.
Good, very good. Ding, 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 ding. If you hire a licensed assistant, who's going to pay that licensed assistant? The broker. Ding, 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 ding. Very good, because they have a New Jersey license. All right. Can that licensed assistant do anything that you can do? The answer is yes. If they have a license, they can do the same thing that you can do, right? Because they have a license. So if you ask them to make a phone call, can they make a phone call and talk about real estate? Okay, if you ask them to go to an open house, to do an open house for you, and their licensed assistant, can they do that for you? Yes. If you ask them to hand out brochures at a trade show, can they do that for you? Yes. All right. So they have a license, even though they're working with you as an assistant, the answer is they can do the same exact thing that you can do, which in this case is a good thing, because God forbid anything happens to you, they can take over and do the stuff that you need to do because they have a license. All right. How many hours is the salesperson course?
$75.
Good. Ding, 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 ding. And how long do you have to take the state exam and get licensed?
1 year.
Okay, from when? Once you pass the school exam. Ding, 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 ding. All right. If in the preceding 5 years, you were involved in criminal conspiracy, fraud, etc., can you get a license? No, that is correct. Do you have to disclose your Social Security, and why? For child support, that is the correct answer. Ding, 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 ding. Does New Jersey have reciprocity with other states? No, it does not. That is the correct answer. How many hours is the broker's course? 150 is correct. And is there an additional experience requirement? And if so, how many? 3 years. Is that 3 years full-time, part-time?
Full time.
3 years full-time is the correct answer. Ding, 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 ding. And full-time is considered how many hours?
Is it 40 a week?
Hours. Ding, 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 ding. If a broker wants to open up a branch office, can that broker manage 2 offices? So the answer is no, that is the correct answer. So what must they do? Hire a broker salesperson, ding, 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 ding. Must that broker salesperson be in the office at all times? Yes, okay. Must they be there 40 hours? Yes, ding, ding, ding. Does the broker of record, the owner of the company, if they're taking care of the main office, do they have to physically be in the office? Yes, ding, 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 ding. Can either the broker or the broker salesperson manager, can they have a part-time job? No, ding, 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 ding. If the salesperson who wants to become a broker salesperson, can they have a part-time job? How many hours are they allowed to have a part-time job? All right, not to exceed 25 hours. That is the correct answer. Not to exceed 25 hours. All right, we got that. We did good on that one. Oh, how much, to whom is the state test fee paid to? Testing center, ding, 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 ding. That is the correct answer. When you go talk to a broker because you want to get licensed, how much is the license fee for a salesperson? $160. Good. And that check or bank check that's going to be written for the $160, to whom will it be written to?
The New Jersey licensure and banking?
Nope. It'll be the New Jersey State Treasury. That's to whom it would be written. Okay. If a person that is not a New Jersey resident, but they want to get a New Jersey license, can they do that? All right. Do they have to sign something special? Irrevocable consent, ding, 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 ding. That's the right to be sued, ding, 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 ding. Corporations, if corporations want to do business in real estate, must anybody have a license? And if so, what kind?
One person needs a salesperson's
Oh, no, not salesperson,
or a broker.
broker person, right? So one of the officers must have a broker's license, and they are then responsible for any real estate transactions. If a salesperson does something wrong, the broker sees it but doesn't do anything, what kind of discipline can the broker get? Oh, you're on the way, Sharonette, that's good. So I'll take guilty knowledge is the correct answer. All right, the broker can get fined or disciplined on guilty knowledge because they knew about the wrongdoing and did not do anything about it or to correct it. So that would be guilty knowledge. What is the maximum amount that we can get fined? $50,000, ding, ding, ding. If you get 3 violations, do you lose your license or can you keep your license? Your license gets revoked. Ding, 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 ding. The guarantee fund. The guarantee fund is set up for what and who administers it? It protects the public, ding, 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 from what? The Real Estate Commission administers it, ding, ding, ding. From real estate licensees, yes. And what did these real estate licensees do? Incompetence, okay, violations, okay, good, ding, fraud, good, ding, 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 ding. How is the guarantee fund funded? Where does the money come from? $10 salesperson, ding, 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 $20 broker, ding, ding, ding. And is this from the first time licensing or is this from renewals? First time licensing, ding, 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 ding. Okay. If the public was violated by a unscrupulous licensee and they're going for the judgment, do they have to name the Real Estate Commission to let them know that they're going after the guarantee fund? Yes, ding, 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 ding. All right, what is the maximum amount per offense that the guarantee fund will pay? $20,000, ding, 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 ding. Can a real estate agent or the spouse of a real estate agent go after the guarantee fund? No, ding, 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 ding. All right, let's continue on. Oh, the broker, they must have 2 bank accounts. And one of the bank accounts would be a trust or escrow account. Yes, ding, 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 ding. And the trust account is set up for what reason? Okay, I'll have trust and escrow account for client deposits. Good, ding, 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 ding. How soon must a check, a good faith check, be deposited, and does it get deposited into the escrow or the business account? And how soon? 5 business days, ding, 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 ding. Very good. Okay, and it gets deposited into the escrow account, ding, 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 ding. All right, if there's no monies in the escrow account and the bank happens to charge the broker to keep the escrow account open, can the broker put personal monies in just to cover the bank fees? Yes. Okay. If there was monies in it and the broker put personal monies into it, what would that be called?
Commingling.
Commingling, ding, 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 ding. If there through legal written agreements, there's monies in the deposit in the trust account, and part of that is going to be used for the commission for the broker. Must the broker take the monies out, and if so, within how many days? Five business days, ding, 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 ding. That is the correct answer. Because is commission considered personal money? Yes, ding, 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 ding. All right. What is, when we're talking to anyone, whether it be on a listing agreement or whether we're talking about a contract, what must we always make sure that these individuals get after we've filled out the paperwork? And this copy that they get, must that be given to them immediately, or can you wait a week or so? Must be given to them immediately. Ding, 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 ding. Are we allowed to sell commercial real estate? Yes. Okay. When we prepare contracts for what kind of real estate? Okay, I need to be more specific. One to four units is the correct answer. Ding, ding, ding. One to four family units. Ding, 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 ding. Plus a vacant residential lot. We prepare contracts for that. So if the property that we are talking about right now does not fall into this framework, what would we have to write up in order to be part of the transaction? A letter of intent. Ding, 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 ding. Okay. If we have a seller who has a very sick child and does not want to cooperate with other brokers, and specifically does not want to be put onto the MLS to cooperate with other brokers, what must that seller sign? A waiver of cooperation. Ding, 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 ding. Waiver of broker cooperation. Ding, 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 ding. Does that also allow them something else because they're signing off on a waiver of broker cooperation? Are they also reserving the right for something else? No, Allison, that's incorrect. So if we have a waiver of broker cooperation, what kind of a listing do we have? Nope, not open. Nope, not dual. Exclusive agency. All right, so if we have an exclusive agency agreement, are they also reserving the right to not do something? And if so, what is it?
Can't they refuse the right to sell to somebody as long as it's not under race or discrimination or
No.
race or
Nope,
color?
that's not the reservation. Nope. Anybody else? Good guess, Eric, but that's not the correct answer.
Can you repeat the question, please?
Okay, so if the seller signs an exclusive agency listing, with or without the waiver of broker cooperation, what are they reserving the right?
that they can sell the property on their own
and
and then not have to pay commission.
ding, 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 ding. That is the correct answer. So if the seller is signing an exclusive agency with or without waiver of broker cooperation, they're reserving the right to sell the property on their own and not have to pay a commission. All right. So what kind of listing do we always want to get?
Exclusive right to sell.
Ding, 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 ding. That means it doesn't matter who brings the buyer, we're all going to get paid. All right, ding, 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 ding. Okay. Letter of intent, we did that already. Okay. All right, so let's go back to the definition of fiduciary. Not the responsibilities. I just want the definition for fiduciary. Anybody?
Isn't,
Okay.
isn't it reasonable care?
No, so the definition for fiduciary is one of trust and confidence. Alexia, you were on the right track. Everybody else had the right idea, but the actual definition is one of trust and confidence. That's fiduciary. And then our responsibilities, all right, again, it's correct. Acting in the best interest of the client, right? Putting them above our interest. Would that be a fair statement? Yes, okay. Obviously, if we use old car, so it's obedience. We have to obey anything and everything that they say as long as it's lawful. We owe them loyalty, right? Good. D is for disclosure. We have to disclose. C could be care or confidentiality. A is accounting, right? And R is the last one, which is the reasonable care and fair and honest dealing. Okay, so that's basically it. If we are talking about a latent defect, what does that mean?
It's a problem that can
defect
present itself in the future. I'm sorry, yeah.
A problem that could present itself into the future. I don't think that would be a good answer.
Something that's not visibly noticeable.
Correct. Latent basically means hidden. So therefore, if there's a latent defect, there is a hidden defect that we don't know anything about. Cannot be seen with visual inspection. That is the correct answer also. Ding, 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 ding. Could it be a potential problem in the future? Yes, but if we don't know it exists because we can't see it, that's why that answer, Eric, would not have worked. All right, would it have been, is it realistic what you stated? Yes, but is it to what the state exam wants? No. Anti-Sherman Trust Act, what is that about?
It's to prevent price fixing.
Okay. And price fixing between whom?
Different brokerages for
Ding, ding, ding,
commissions.
ding. Okay, so there's price fixing, all right. What is blockbusting? Competition
Steering.
regarding that? Yep, panic peddling. That's a good answer. Steering, okay, so what is steering?
moving someone away from an area.
or to an area, away
Yeah, or to an
or to an area. Okay, good. Ding, 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 ding. All right, so that takes care of that. If we had innocent misrepresentation, what would that be? What could that be?
Someone who believes that the information is true, and not willingly knowing that it's not. Does that make
Okay.
sense?
Yep, that is that is a good definition. That is correct. So you didn't know whether it was true or not. You didn't, and so the answer to that, the Gloria speak, is trust but verify. You trusted them, but you didn't verify. Okay, so in this case here, that would be innocent misrepresentation, just like I stated that I said that the stove was working, but I didn't verify that it was working. I just automatically presumed that it was working, and until I tried it, then that would be innocent misrepresentation. Megan's Law, what is that about, and who is allowed to disclose the information? Sex offenders, okay, ding, ding, ding. And who is allowed to disclose that information, and at what point does this information get disclosed? Direct client to the website, yes, you can do that. Prosecutor's office after closing, that is the correct answer. Not after signing the contract, no. The correct answer.
Gloria, I have I'm
Yes.
sorry, Gloria, I have a question about that. You know how we all say about disclosure, but what if, so the only thing we can tell a client is to go to the website. We can't say we know Charlie next door is,
We cannot
is a
disclose.
we can't.
That's
So
violation.
strange. We can disclose everything but that.
That's correct. That would be a violation of the law.
Okay.
It's a violation of the law. It's not just a violation. It's the violation of Megan's Law. And the correct answer is, when is it disclosed and who discloses it? You have that correct. The prosecutor's office after closing. So the other correct answer would be after the transfer of ownership, or if we are talking about a lease, after the transfer of possession and occupancy to the new tenant. All right. After signing the contract is incorrect. All right. So the key answer is after the transfer of ownership or after the transfer of possession and occupancy of the property. All right. Very important. Okay. Errors and omissions, what is that? Who pays it? The agent pays it, okay, and what is it? It's insurance, okay? Would it be similar to malpractice insurance as a doctor? Yes, okay, good, ding, 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 ding. Consumer information statement, okay, I want to go to that because I want to get to the correct answer that you're going to be looking for in the state exam. All right, hopefully I can find it. Oh, there it is. Disclosure, right? Okay. Oh, here it is. Okay. Okay, so required to furnish the information. Here's the correct answer. This is the answer that is going to show up on the state exam. All right. Before any discussion of motivation or financial situation is initiated. If you don't have that phraseology in there, then my answer to you is at the first meeting, right? We had one of those questions on one of the tests that we had. So if this is not in there, or a version of this is not in the multiple choice, then the answer is going to be at the very first meeting, first possible meeting, or something to that effect. All right, are we all good with that? Okay. Is undisclosed dual agency legal? No. All right, no. Very good. All right, oh yes. So how do we, so when do we, let me ask you this. When do we start agency? How does agency get started? An agreement between an agent and a client. That is the correct answer. Ding, 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 ding. Could it start verbally ahead of time? The answer is yes, we have that. Could it also start by action? Expression? Action? Can it start that way? Yes, 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 yes. Ding, 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 ding. All right. So if we start out verbally, or we start out with actions, and the perception is that we are representing that individual, must it then be eventually put into writing? 5 days. Good. Ding, 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 ding. And which takes precedence, the verbal one or the written one? The written one. Ding, 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 ding. All right, good. And how do we terminate? So, okay, so written, yes. Okay, having an agreement with the client is the correct answer. So how does, if we were to be talking to a seller, how would we start a client relationship? What would initiate the listing? Ding, 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 ding. Okay, so now that we have this listing, what could terminate the agency? Mutual agreement, ding, 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 ding. Expires, ding, 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 ding. Closing, ding, 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 ding. No contract, okay, ding, 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 ding. What else? I don't know about broken promises. I can't answer to that. Bankruptcy, ding, 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 ding. Incompetence, ding, 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 ding. Death, ding, 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 ding. Now, death. Is it the death of the salesperson, or is it the death of the broker? Death of the broker, ding, 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 ding. All right, good, 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 good. All right. We've talked about dual agency. I think we know that pretty well. All right. Consumer Fraud Act, okay? The Consumer Fraud Act, is that the law that makes us put everything in writing so that it is enforceable? Yes, ding, 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 ding. All right, so the Consumer Fraud Act is what is the law that makes sure that if we put it in writing, then it becomes enforceable. All right. All right, we talked about the antitrust. All right, ethics. So breach of fiduciary duties. So let's discuss fiduciary duties again. If I don't comply with my client's instructions that I have to give them 24-hour notice to show the property. Would that be considered a breach of fiduciary duties? Yes, ding, 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 ding. If there's a conflict of interest because I am interested in purchasing the property, but I did not let the seller know about that, would that be a breach of fiduciary? Yes, good. Ding, 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 ding. All right, those are the most important ones. All right, so a net listing. What is a net listing and is it legal in New Jersey?
It's illegal in New Jersey. It's when you don't go by the comparable market. You can get a big benefit out of it.
All right. So basically, the easier way to remember is that if to keep anything over a sales price, right? Or over the price, the monies that the owner wants in their pocket. That is the real correct answer. So the owner tells you that they want a certain dollar amount in their pocket, and you can then name the sales price anything over that. All right, and anything over what the owner wants in their pocket is then your commission, and that is illegal. And would that constitute that it is not in the seller's best interest?
Yes.
And why?
The seller could get a better deal somewhere else anyway.
Ding, 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 ding. That is the correct answer. Ding, 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 ding. If we were talking about, if I were to put an advertisement in the newspaper, all right, and I stated that they can get a mortgage at 6% interest with a long term, would that be considered trigger terms? And what would I have to do based on that little bit of information? For qualified buyers, yes, but that's at the very end. What else must I do based on that little bit of information that I gave? Anybody else? Yes, thank you very much, Allison. I would have to explain the monthly payment, the down payment that's required, the actual percentage, and I would have to give the APR, the annual percentage rate, and then to qualified buyers, and keep proof of the information for how long? Thank you, Zara. For how long? No, in this case here, this advertisement is for 1 year only. The advertisement with the trigger terms would be kept for 1 year only. All right, it's just an advertisement, but the brokerage company would have to keep it for 1 year. Okay. If there was a listing, and it's stipulated, I'm the listing agent, okay? And in the listing, it states that the refrigerator does not go with the sale, all right? And I get a contract and I don't read the contract, I just send it to the seller. And then at the closing, the buyer is upset because the refrigerator is not there. Whose fault is it? Okay, yours is who? The seller salesperson, the buyer salesperson? All right, so the answer, it would be both, right? Because if I had it in the listing, and the buyer's agent did not put it into the contract, then the buyer agent is at fault, part one. And if I did not read the contract, then I'm also at fault because I didn't catch it at that point in time. So would that be a breach of fiduciary duties? Yes. Ding, 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 ding. The answer is yes. Okay. Oh, dual contracts. What is considered a dual contract? Nope, that's not a dual contract. Nope, that is not a dual contract. Nope, that's not a dual contract. Everything that you guys are stating is dual agency, but that's not a dual contract. Attorney and broker, nope, that's not a dual contract. All right, so let's go over that. It is illegal. You are correct, Allison. It is illegal. All right, so there we go. Tom's got the right answer. One has the true price, one contract has the true price, and the other contract has a larger amount because they want to take cash out. So the true price contract goes to the seller, and the larger amount contract goes to the mortgage company. Ding, 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 Tom. Great job on that one. All right. All right, we know about the National Association of Realtors, that they have the Code of Ethics that was adopted in 1913. Realtors is a trademark. The New Jersey Realtors used to be called NJAR. It's now New Jersey Realtors. So it's the New Jersey Association that we all belong to. All right. Oh, what is Mount Laurel 1 and Mount Laurel 2, and what was it trying to correct? Okay, affordable housing, low and moderate income, discrimination on low and moderate income. Okay, but the actual word that it's trying to correct is none of those words. It is regarding all of that, zoning, and more specific, Zara. What kind of zoning? Exclusionary zoning. Ding, 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 ding. Nope, exclusionary zoning is the correct answer. So Mount Laurel 1 and Mount Laurel 2 was correcting exclusionary zoning, and it was regarding, as everybody stated, affordable housing, low, moderate income. It was a discrimination against low, moderate income housing or brand new construction for that. And so in this case here, did the Mount Laurel designate that all towns, if there's any new construction, that there's a certain percentage must be designated to affordable housing? And if so, does anybody, oh, you got it, ding, 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 20%. All right. Does it apply to resale or does it apply to new construction? New construction, ding, 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 ding. And how long is this affordable housing deed restricted for? Not 5 years, longer. Anybody? All right, so the correct answer is 30 years. The deed is restricted for 30 years. Okay. And can any rich hotsy-totsy town allocate their allocation to another town? Nope, that is the correct answer. Ding, 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 ding. Does the Fair Housing, does HUD, the Fair Housing and or Real Estate Commission have testers or checkers that are volunteers? Yes, ding, 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 ding. Title 8 is known as what? No, Title 8, not Title 1 or Title I. Title 8. V111 or VIII. Ooh.
It is the section of the Civil Right Act covering housing.
Ooh, good, Allison, good. It is basically describing the Federal Fair Housing Act of 1968, or also known as the Civil Rights Act of 1968, Title 8. All right, so it has to do with federal fair housing. Okay, very good. So now, if I feel that I was discriminated against race, right? Where would I go with the complaint? Federal, state, local? Federal, good. Ding, 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 ding. If I felt that I was discriminated based on the Federal Fair Housing Act, how long do I have to place a complaint? Ooh, you guys are mixing it up. Some of you got it right, some of you don't. So let's go over that. The Federal Fair
Is it 90 days?
Nope. The Federal Fair Housing Act, all right, let's get this straight. The Federal Fair Housing Act, if I felt that I was discriminated, I have 1 year to complain to HUD. Okay, so I have 1 year to complain to HUD. And if I want to elevate it and make it a federal, then I have 2 years to make it federal. All right. Now, let's go to the New Jersey law against discrimination, because again, some of you got that mixed up. So if I feel that I was discriminated based on the New Jersey law against discrimination, then the answer to that is that I have 180 days to complain to the Attorney General's office. All right. So that this should help unconfuse all of you. Are we all good with that? Let me go here for a second. No, I don't want to go there. I want to go drive. Are we all okay? All right. So let's just go here for a second. Let me just pull something up here. Give me a second. Goes the wrong way. All right, school. I know you guys have it, but let's just go over it here. No, that's not the one. All right, so here we are. Well, let's see if I can make it open with. All right, let's just go over this because this is a big deal now. I might have to change it. There might not be. So again, you need to know the protected classes. All right, so I would try to remember them. Okay, not necessarily the year. I wouldn't worry about the years, but I would try to remember them. So again, race and color, never. Okay, federal fair housing is race, color, religion, national origin, sex, handicap, and familial status. So what does, the files are in Google Classroom. So what does familial status mean? Okay, I need to, Marissa, that needs to be more specific.
How many people in the home?
Nope. Under the age of 18. Ding, 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 ding. That is familial status. That's the specificity of it. Okay. It applies also with the New Jersey law against discrimination in rentals only. Okay. Now, in the New Jersey law against discrimination, we cannot discriminate against marital status, which reminds me, I was wrong. I don't know if it was yesterday's test or today's test that we went through. You cannot discriminate against marital status based on New Jersey law against discrimination, all right? Nationality, ancestry, affectional sexual orientation, source of income, we cannot discriminate against. So when they're talking about the source of income under NJ LAD, what would they be talking about?
Public assistance?
Ding, 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 ding. Very good. That's a very big hot button right now with fair housing. All right. It's a very big hot button. Again, we stated that under the federal fair housing, the property covered is only residential property, and under NJ LAD, it is all properties. Okay. When we're talking about lenders, in federal fair housing, it's institutions, meaning banks, mortgage companies. Under NJ LAD, it means anybody, anyone that is lending money, all right, must abide by the NJ LAD law, all right? If we're talking about exemptions, all right, it again, under the federal fair housing, if the broker is not involved and the owner doesn't own more than 3 units and they're not discriminating, then they can again be exempt on discrimination except for race and color. They can determine who they want to sell their property to or who they want to rent it to, all right? In New Jersey, NJ LAD, that only applies if they're going to be renting it and they occupy 1 unit. All right, very, very important. Okay, and that's only for 1 to 2 family, whereas under the federal fair housing law, it can go all the way up to 1 to 4 family. But again, the owner must occupy 1 of the units. All right. Are there exemptions for religious organization? Yes, across the board. Exemptions for private clubs? Yes, for federal fair housing, as long, again, as the private club, the member-only club, is only for members and it's not commercially. In other words, the public can't go there. NJ LAD, no, nothing. All right. Denial of entry into the MLS. They have that for fair housing, nothing set up under NJ LAD. All right, so basically we don't discriminate, period, end of story. And again, the enforcement, all right, so we said federal court for Civil Rights Act, so race or color. For fair housing, 1 year you complain to HUD, and then 2 years if you want to make it into a federal lawsuit. For New Jersey, we are much stricter. So it has to be 180 days, and it's going to be complained to the Attorney General. All right. The fines, as I told you earlier, with the fines, I did update it. So with the fines for federal fair housing, if they're going to be talking about fines, you just know that they're odd numbers. They're not 0 zeros. So you know they're talking or asking a question about federal fair housing. Whereas in the NJ LAD, you need to know 10,000, 25,000, and 50,000. We already discussed that there is no such thing as you can have more than 3 violations. You're going to lose your license with 3 or more. All right. Right. Okay, so that's the main distinction between the federal fair housing and the NJ LAD, and they're going to go into any one of these that we just covered. All right, are we all good with that? Did that help you? All right. Okay, so that's that. Then the other one, agency, let's see if I have anything in here that I want to go over with real fast. No, oh wait, what's the tables? Question regarding commission and exclude, okay. Commission and exclusive listing, all right, good. So here's the table, well, this you already know, so we don't need to worry about that. All right, so let's talk about, you're talking about listings, all right? So let's go to listings, actually, we could probably go here to listings real fast. All right, so chapter 10 is listings. All right, so listing agreement. We have an open listing, which means that I'm the owner and I can go to a whole bunch of different brokerages and I say, hey, I got a property for sale. And if you bring me a buyer, I'll pay you a commission. All right. But I am not agreeing to just be with one office. I'm not signing any agreements. I'm just saying, if you have a buyer and they like my property, I will pay you a commission. Exclusive agency listing, okay, is the keyword is, let's start out with the keyword exclusive. What does the word exclusive mean? It basically means that the seller is willing to attach themselves to one brokerage company. I can't find another word, but hopefully that helps you. So they agree to be attached to one brokerage company. Okay. And so now, if they're saying they want an exclusive agency, it means that they're willing to be attached to this one brokerage company, but they are reserving the right to sell to a buyer and not pay us a commission. That's an exclusive listing. Or if we have a seller that wanted the exclusive listing, but they've also signed off on the waiver of broker cooperation, then basically what they're saying is, I'm attached to you. I believe in you. All right. But because I have a sick child and everything, I don't want it to go out onto the internet. And I don't want any of the other agencies and their salespeople coming into my house to show the property. I only want you, the broker, my exclusive broker, and your salespeople to show my property. Again, because I have a very sick child and I just don't want to have a lot of traffic. But I also want to reserve the right that if I find a buyer for my property, that I'm not going to pay you a commission. So that's what exclusive agency is all about. So Zara, did that help you? Okay.
Yes, thank you. And how the broker will be paid? So the buyer will be paying him, or?
No, the seller pays the commission. All right. So if the owner brought their own buyer, we're not getting paid for anything.
Okay.
All right.
Okay, thank you.
You're welcome. And again, we don't want to talk about exclusive agency because why? Are we violating the code of ethics? Yes, we are. Because we're saying we're not going to be cooperating with the other brokers. It's only our agency that has this listing. Right? If we have the waiver of broker cooperation and we have the exclusive agency listing, doesn't that mean that we're not cooperating with the other brokers? Right? So isn't that a violation of our code of ethics? isn't our code of ethics is that we have to cooperate with all the other brokers? Correct. Yes. In other words, we're not going to offer it up front. Now, if the way the seller is talking to you about it, I mean, we're not going to be stupid, right? We're not stupid. So if the seller is talking to you about it and you can't talk them out of this talking about this kind of a situation, then yes, you're going to say, yes, that is available. I don't think it's the best way to market your property. It's not in your best interest because there's not going to be it's not going to be out on the market to the whole world. It will only be on the market just for a small amount of people to know about. All right. So, again, we're not offering it up front, but if somebody's talking about it and you know where they're heading, then you can't say, no, it doesn't exist. You are going to have to deal with it and try to talk them out of it. But they might have a legit reason for that, for their situation as to why they need it. A lot of times, again, in the hot market, a lot of times there may have been exclusive agency because that would be considered also a pocket listing, so that nobody knows about it except for that brokerage company. All right. So this way they could try to sell it and get both sides of it. All right. That's another reason why people use exclusive agency. Not the most ethical, but it does happen. All right. What about maybe in the case of a for sale by owner? What about in the case of a for sale by owner? All right, I'm dead. So Stephanie, you'll have to explain it to me. I'm sorry. I'm brain dead right now.
Yeah, I'm saying so exclusive agency is when they have the ability to sell on their own, but if you bring a buyer, then they provide a commission, right? So
Well,
I mean,
that wouldn't be
go ahead.
Okay, so now I know where you're heading. Okay, so the answer is depends on which way you're going. So I will phrase it in several ways. So you're talking to a for sale by owner, okay? And they say to you that, all right, I will pay you a commission if you bring me a buyer, but I don't want to sign anything. All right, there's nothing there. If you do an exclusive agency listing, whereby if you're the one that brings the buyer to them, all right, and they're listed, the key is they get listed. If you have an exclusive agency listing, it means that it's listed and it's going to have your sign on the front. All right. So in most cases, when you're dealing with a for sale by owner, you're just going to write up some sort of something in writing stating that if you bring a buyer, that they agree to pay you whatever the commission you negotiated with that person. And I would certainly give them a copy and have myself a copy. All right. A lot of times they don't want, unless they're ready to get listed, like in real form, get listed. Most of the time, they don't mind working with you and pay you a commission without getting listed, if that answers your question.
So it doesn't have to be an actual listing agreement, just an agreement of
They
our
have to sign
agreement,
off
for
on
lack
that.
of a better term.
You need to protect yourself, right? So here's another example. I'll tell you what I have done, and maybe this might, again, like I said, I'm sorry, I'm getting brain dead. And I'm sure you guys are worse than me. When I had my buyer, my $3,000 furniture buyer. Okay, so we were looking at properties and everything we saw would just, it just wasn't working out. So I saw these people building a property, right? I mean, they're doing construction on this property. And so basically I went, knocked on the door and I said, are you willing to sell the property? And the guy said he had to talk to the owner, and I called and I talked to the owner, and he said yes. So I said, okay. And so when I got his phone number, so I texted, my buyer's name is such and such, and we're talking about property such and such. My name is such and such, and I will be sending you a contract. All right. What are you paying for commission? So then he texted back in response to what he was going to pay me a commission, right? And then what I did was I wrote up the contract, and then I sent him the contract, and now we have a full-fledged contract. Did that help you any better? And did that help you, Stephanie, or anybody else?
Would you just be a transaction broker at that point, or would you be?
I
Well,
am a
no,
buyer's
actually,
agent. I'm
you'd
a
be
buyer's agent. Yeah,
Okay, and then he would have to pay the commission though to the broker in order for you to get paid.
absolutely. Yes, yes. It's no different. I just don't have a quote official listing, but I have a real contract with that builder, right? And he's going to hire his attorney, and my buyer's hiring her attorney. So it's just the same thing. The only difference was we had no paperwork to start to have it official, so to speak, on the market. Is that a better way of saying it? Okay, Stephanie, are you still slightly confused? Or present to me an offer of what you're thinking about.
No, you answered my question. I got more confused when you did your example, because I was thinking more so with the exclusive basic, well, I don't want to say convincing a for sale by owner, but getting a for sale by owner to go into contract with you, but yet they still have the opportunity to sell without you.
Okay, and I wouldn't do that. If I am going, so here is what I will tell you, all right? Because I don't, as I've stated before, I don't trust anybody, and specifically for sale by owners, all right? Because they already, as it is, they don't believe in us as agents, all right? So if I'm going to be trying to talk to a for sale by owner, they're just as hesitant about signing with a broker as I am really hesitant about working with them, because they really don't believe in a realtor. All right. They don't believe in us because they figure they can do a better job than we can. I'm not saying that they can't, and I'm not saying that they can. I'm just saying that is their belief system. So I would not go with an exclusive agency listing, but because why am I going to give them the opportunity to try to sell when they already had that opportunity as a for sale by owner? Right? So I would, if I'm going to be working a for sale by owner, I would definitely be going for an exclusive right to sell, because and you're correct, Allison, and the agent is doing all of the work, and you are marketing that property. So you are spending your own money. So when you're talking with a for sale by owner, you just continue talking to them and be nice with them and blah, 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 until they come around to believing that you can distinctly help them. All right. And when they get to that point, then you want an exclusive right to sell, because what we're trying to tell them is that by doing the exclusive right to sell, we are putting the property on the market for everybody, not just an exclusive section of real estate. We're allowing everybody to see that this property is on the market. We are allowing everyone to bid on this property. And when I mean everyone, I mean agents with all of their buyers. Okay. And on top of that, if I'm marketing a property, I'm spending my own money, right? And so if I'm going to be spending my own money, I want to get paid no matter who brings the buyer. All right, because I'm going to be doing photographs, whether I hire again, it's going to depend on your brokerage company. Like all the brokerage companies that I'm with, they expect professional photographs. They don't want that iPhone photograph. You can do an iPhone movie or a Android movie, but professional photographs, they want professional photographs. All right, so I'm going to be spending what, $400 or $500 only so that he can turn around and sell it to somebody and not pay me a commission. That doesn't make any sense, and that's not good business. Is that a better way of explaining it, Stephanie? All right, and I'm not telling you not, and okay, don't, and again, don't misunderstand. I am not saying not to work with for sale by owners. I'm saying by all means work with for sale by owners, and if you can get a buyer to come and buy their property, go for it. All right, and write up a contract and all of that. But if you're trying to get them as a listing, I would wait until until you can feel, and trust me, you can, when they're ready, when they are ripe to list with you, because by this time, usually it's a month and a half that they've been on their own. They're tired of getting the phone calls in the middle of the night. They're tired of people knocking on the doors. Oh, can you tell me how much your house is worth? Or can I take a look at your house? And so on and so on. And so, obviously in the market that we just passed, that's a whole different story. I'm talking about now going forward. It's going to be a good opportunity, but you want to get them to be ready and ripe to that they believe in you 100%. All right, that's really the basis of it. I like for sale by owners personally. I like having a buyer and searching for sale by owner. I can't say I'm very fond of going after a for sale by owner for a listing, and I am I'm a listing agent. I prefer doing it on the other side. All right, just to give you another viewpoint. All right, everybody good? Any other questions? This is good. This is good. In an open listing, a seller can sign an agreement with many brokers at the same time. Yes, that is correct. Yes, that is correct. They can sign an agreement and just say that if you bring me a buyer, I will pay you a commission. That's really what it's all about. And again, an open listing is another version of a pocket listing. So again, here's another example. So it's a hot market again. Let's just say we're still in a hot market. There's not much properties out there. There are a lot of buyers out there. And you come across somebody and they said to you, Gloria, I'm really thinking about selling my property, but I'm just not ready yet, and I have talked a couple of times and all of that. So in your daily business, if you come across any buyers that are looking for, my property, what my property looks like and my price is whatever, then, I'll pay you a commission. So that's a typical open listing. That's also a typical pocket listing, so that if I'm with buyers and I've shown them everything that's on the MLS, right? And nothing suits them. And then I go, oh my God, that's right. I forgot about Joe Schmo. Joe said he was interested in selling his house. Okay, hold on a second. Let me call Joe and see if we can set up an appointment to show his property. Now, do I have anything in writing with him? No, I don't. But he said he's interested in selling. Hey, Joe, I'm calling because I got a buyer. Can we come by in about an hour to show your property? You still thinking about selling? Yeah. Okay, good. So now there's no other properties that I can show these buyers except for this quotation marks pocket listing. Now, he might have talked to a whole bunch of other realtors as well. So a whole bunch of other realtors as well might know about it, but maybe nobody took advantage of it. I'm taking advantage. I'm calling, going over to Joe Schmo's house. The buyers fall in love with it, and we've got a contract. All right. So that's an open listing, as they call it, also a pocket listing. All right, so if you are a buyer's agent and you find a for sale by owner that the buyer is interested in, would you then create a dual agency? No, because I'm representing the buyer. So that you still only be in contract with the buyer. All right, so yes, so the answer is, and again, the legal definition of dual disclosed agency is that, do we have an agreement with both parties? Let me ask that question first. Yes, right? There's a listing agreement and we're writing up a contract offer with the buyer. We may not have a buyer agency agreement with the buyer, but we're writing up a contract offer on this property that's being represented by the brokerage company. That's classic dual agency, yes? Okay, so in your question, if it's a for sale by owner, is he listed, is that for sale by owner listed with anybody? No. Have you been working with this buyer and you've been showing properties, and let's be totally legal, you got a CIS form? Therefore, you are representing the buyer, true? All right, so you knock on the for sale by owner and you show the house to your buyer and your buyer likes it. And prior to that, would you have talked, prior to showing the house, let me ask you this, would you have spoken to the for sale by owner and asked him, is he willing to work with realtors? Okay, would you have asked him what he's willing to pay in commission? Yes, right? And you would make sure that you would write, like I said, I told you, I carry a little notebook, right? So if the buyer's in my car, we were driving in my car, we knocked on the door. So I would take my notebook and I go, okay, Mr. and Mrs. Buyer, address. I'm showing the property to Nancy Drew, and you said you're willing to pay me a 3.5% commission, whatever it is, 3.5% commission if Nancy Drew buys this property. Mr. and Mrs. for sale by owner, you sign it, I sign it, I give them the original, I'll take a photograph of it, so I have a copy of it. Then I go show Nancy Drew the house, she loves it, then I'm going to go back and write up the contract. All right, did that help you on that one? I got lost here.
Yes, thank you, Gloria.
All right, so
Gloria, do you have for sale by owners yell at you?
yes, of course. Yeah. I said, I don't want to deal with any brokers. Well, your sign doesn't say that. Well, it's on the listing. Well, I don't look at it for sale by owner.com. You know, I'm driving my buyers in the car, right? They're just, you know, the adage is sellers are yellers and buyers are liars. And you'll find that to be true. All right, so for sale by owners are yellers, right? All right, question regarding, okay, exclusive, what about the main for sale? Agent is doing all the work, right? That's true. In the open listing, yes, that's true. If the buyer's agent, okay, and again, now you can have, so let's make it the reverse. Let's say the for sale by owner says, I'm not gonna pay a commission, all right? Now, again, understand that, okay, so I'm reading something else, but if let's say you knocked on the door and you got Nancy Drew in the car and you go, well, so are you willing to work with realtors? Yes, I am. And so what are you offering as a commission? Because it is negotiable. Well, I'm not willing to pay any commission. And I'm going, okay, well, then I'll have to talk to my buyer to see if she would be willing to pay a commission. But you do realize, Mr. and Mrs. for sale by owner, that whatever price you're asking, that's not including the commission. So I would have to lift the price up to include the commission so that the number that you're asking right now might be the actual number that you get. A lot of times they don't think that way. All right. So in other words, if let's say they're selling it at $350, right? And I want to get, let's say, a 3% commission, then in that case, I'm going to have to do my math to add the 3% on top of the $350. Does that make sense? All right, because a lot of times they don't think that way. And so therefore they think that the 3% is going to come off of the $350. But the reality is the price is going to be higher so that it includes your commission. All right. So I just want to clarify that as well.
Obviously, the buyer has to agree to that. Correct?
Well, it depends on which scenario we're going to go to. If the seller says, yes, I'll pay the commission, and you go, okay, just want you to know, we're going to raise your asking price to include the commission. If the for sale by owner says, no, screw you, I'm not paying no commission. Why do you think I got it for sale by owner? And so, so then I'll have to say, well, all right, we'll just have to wait a minute. I'll have to go talk to my buyer to see if she would be willing to pay the commission. If she's not, then I'm sorry, I'm not going to be able to sell your property. Gee, that's too bad. I'm sorry. Goodbye.
Hello.
Hi, goodbye.
Goodbye.
All right. Is that helping out? Okay, so what do you do when you want to sell your own house? Do you have to sign an agreement with another salesperson, your broker? No. Again, it's going to be, again, understand it's what the whatever their rules and regulations is in their independent contract agreement. But typically it's going to be, it may be in your own name or the broker's name. All right, but no, you don't need to hire or put it to another salesperson in your brokerage. It's either going to be you or the broker. All right, and then it's going to depend on what their rules and regulations are regarding that. Okay, anybody else? This is good.
Can I just ask another question?
Sure.
So if you're raising the listing price, the 3.5% for commission, wouldn't you do that either way, whether the buyer or the seller would be paying the commission if
Oh,
it's not included in the listing price?
Yes,
Okay.
yes, you're definitely going to be doing that. It's just a matter of who's going to be paying for it. Right?
But wouldn't the buyer be paying the extra 3.5% anyhow? Or you're saying that, let's say the listing price is $350, the buyer would pay $350 and then the seller might agree to pay the 3.5%?
Right. So, all right. So let's go back for a moment. Hold on a second. Let me figure this out. This way I can talk better.
I'm sorry.
No, that's okay. No, 1, 2, 3. So 350. So let's make it 3%, right? So that would be times 103 times 103%. So that would be 360. So the asking price. Okay. So you're the for sale by owner, Marissa. And you're asking 350. So go, hey, Marissa, I got a buyer, Mary Drew, out there, and she's interested in purchase. We'd like to see your property, and maybe we'll write up a contract for your property. Are you willing to work with realtors, brokers? Yes, I am. What are you willing to pay commission? And so now that's the question. And so you're going to say, let's say you are willing to pay the commission. So I'll say, okay, Marissa, so your asking price right now is $350,000. But if you're going to pay me a commission, I'm going to up the price so that this way the price is going to include the commission. right? So in this case here, your asking price with the 3% commission is 360,500. Okay. And so now I'm going to go to Mary Drew and tell her, okay, I spoke to the seller. Yes, he's willing to work with us. And so his list price is 360,500. So they're still getting their 350, or we're negotiating it, but they're not losing all of their 350. Right?
Got it.
Okay. So that's where some agents forget about that aspect of it. All right. So because what is the seller trying to do? They're trying not to pay a commission. Anybody going to the for sale by owner, any buyer going to the for sale by owner knows that they're trying to save the commission. So they too are trying to save the commission. So bottom line is, realistically, if we're looking at it, the seller is basically losing not just 3%, they're losing 6% if we're going to go with that number, because the buyer also wants to not pay commission on it either. All right, if that makes any sense.
I might go off the beaten path a little bit, but can you explain a seller's concession?
Okay, so a seller's concession is, it's easier for me to draw. So hold on, let me get to the drawing board.
I can't see your board, Gloria.
You can't see my board?
No.
I'm not there yet.
Oh, I'm sorry.
That's
Okay.
okay. All right, hold on.
I guess I'm tired. Sorry.
We're all tired. Listen, we're all tired. Okay, so let's not. All right, so let's go to stop share. Now let's go to start share, new share. All right, so now you should be able to see. You should see what you that. All right, so share. All right, so now you should be able to see the board. Yes. That's a yes. Okay, good. Thank you. All right.
Yes.
So a seller's concession. All right. So we have the purchase price. We're going to stick with the 350 just to make life easy. All right. So 350. And then there's going to be a down payment. In this case here, it's probably going to be a 3.5% down payment. All right. So 350. Actually, let's just make it set. Let's just wait. Don't wait. Let's just make it, just for easy purposes, 3% down payment. All right. So 350, 1, 2, 3 times 97%. So the mortgage then in this case here, the mortgage is 339,500. I'm just writing everything down as we would on the contract. Okay. In the different spots in the contract, this is all the information that we're going to be writing down. Okay. And then we have the closing date. All right, let's say 12/31/22. All right, so the mortgage company says to you and to your buyer, all right, you know, you're going to, Mary Drew, you're going to need to get a seller's concession of, now FHA, I think it is, allows up to 6% of the loan amount. All right. VA, I think, is the same thing, but most of the time, because not everybody calculates things the same way and people may not remember everything properly. So the majority of the time, the mortgage broker is going to give you a dollar amount. Okay. So he's going, so let's say the loan officer told us that we need a seller's concession of, let's just say $6,000. All right. Okay. So what does that mean to the seller? So basically in this instance, the way we would be writing up the contract is we would be writing, we'd be writing the purchase price as 356,000. All right, the down payment is going to be 3%, and the mortgage is still going to be 339,500. All right, and so then when you do this, you're going to see, you're going to write in the additional contractual provisions, you're going to say that the purchase price is 356,000. However, the seller price is going to be 350,000. All right, so you're going to explain, and that the seller's concession is $6,000. Is that making sense?
So the seller's still getting 350,000.
Correct.
Okay. And the mortgage is still gonna be, so what's the difference? So what is the benefit then of the extra 6,000? Where is that going?
The purchase price. The purchase price is a higher dollar amount. And that has to do with mortgages. And in this case here, it's also going to have to do with the, I think it's going to fold into the mortgage amount, but I don't write it up into the mortgage amount. All right. In other words, my dollars are based off of the purchase price. Okay. My dollars are based off of the purchase price, but I have to add the $6,000 in as a concession. In other words, the sellers were willing to take away $6,000 from the purchase price, which is $356,000. It's kind of like fake money, I guess is the better way to describe it.
Thank you for that.
All right.
Can I ask a question? This is different than the seller giving money to the buyer towards their closing costs, right? That's something
No,
different.
This is
That's the
it.
same thing.
This is the
Okay.
same thing. This would be the
We
same.
had that happen to us once, and I guess they did the math wrong, and the buyer thought they were getting extra money at the settlement table, but they said that was illegal and they couldn't actually take money. But I
Right.
don't know if
And
that's still allowed.
what Karen, so what you're referring to is what the buyers were thinking. They were doing a dual contract where they gave the mortgage person the 356. They offered you let's just use this. They offered you the 350, you're getting the 350, but because they were going to the broker, to the mortgage broker with the 356, that they would get the $6,000. That's what they thought they were doing. But the reality is no, it was paying for their closing costs or whatever extra dollars that the mortgage person told them that they needed.
Right. So they had to give us the money back instead of them having it.
Right, exactly.
Okay. Yeah. All right. Same thing. All right. Thank you.
Exactly that. So basically, yes, it looks like the seller is getting more money, but the reality, the seller is getting the same amount of monies. It's just that the $6,000 is going to apply to the buyer's costs, whatever those mortgage costs are that they're short of. Are we good?
So if I understand this $6,000 is a fake money, so no one will get it.
Exactly. Nobody gets it. Exactly. But it looks like everybody's getting it. Yes.
Okay.
It's just, again, this is mortgages. We don't have to worry about it. You just need to know how to write it up. Okay. So what we did is the correct way of writing it up. All right. But it helps everybody. It helps first-time home buyers who are short by $6,000 or $5,000 or $4,000. It helps them to get over that. All right, it's kind of like a shell game. I think that's what it's called. I don't know, but yes. All right.
And who will be the buyer agents?
Say that again.
The buyer agents. Who will pay him?
Well, the buyer agent is always paid by the seller. The commission always comes from the seller unless it's written up differently. Or unless it's been agreed to differently.
But if I understand in this discussion is the owner who is selling and he is refusing to pay the commission. So how
Well,
with
you have
this?
you have to negotiate with the buyer to get that commission, otherwise you've got nothing,
Okay.
right? If we're talking about a for sale by owner,
Yes.
right? You're talking about a for sale by owner. The for sale by owner said, screw you, I'm not paying any commission. If you want to sell my house, get the monies from the buyer. So you're going to have to talk to the buyer to see if they are willing to pay you a commission. If they are, then you're going to incorporate it in your contract. If they're not, you've got nothing.
Thank you.
And that's the danger. So that's why you want to make sure, and that is a very big danger, because you want to make sure that you have that signature by the seller, whether they pay you a commission or they don't pay you a commission, because you are the one that introduced that property to the buyer, right? And then if you are talking to the buyer about them paying you commission, once again, this little booklet, you're going to write down all that they've agreed to and have them sign off on it, right? Otherwise you have nothing. You have nothing to enforce it. Now, it doesn't mean that you're going to be able to enforce it, but at least you have something in writing to prove to the law that they all agreed to it. Right? Yes, no, maybe, perhaps. Okay, good. All right. So that's basically it. All right. So we're all fried. So let's have a nice 4-night off. Have a happy new year. Okay. And you'll be, like I said, you'll be getting all those tests coming in through Google Classroom. And on Tuesday, I'll see you for the test. All righty. So happy new year. No keyword. I'm too fried. So happy new year. If you want, put in happy new year. But happy new year, everybody. And, oh, guess what? I'll see you next year. Woo-hoo! I'll see you guys next year. All right. Marissa, it was in the chat. You'll have to go back up to the chat to find it. All right. And Karen, I'll see you on the 9th. All right. Okay. So y'all have a good night. Enjoy the
Thank you,
holiday.
Gloria.
You're welcome. And I'll see you next year. Oh, I got to say.
Oh my goodness.
All right, thank you.
Good night.
Thank you.
You got
Yeah,
it.
thank
Bye.
you.
Good night.
Gloria, I came into the class late. Is there any other way to access
Okay,
the
hold
Google
on,
Classroom?
hold on. All right, just give me a second. Hold on. Where am I?
I'm so sorry to
No,
be a
nothing
pain.
to be sorry about. Nothing to be sorry about. I'm not functioning. So hold on. No worries. All right. So where are you? Marissa. Okay, Marissa. Where's Marissa? Hold on, Marissa. All right. So you should be getting it in chat right now. And again, you have to have a
Got
Google
it.
account to be able to access it.
Thank you so much.
You're welcome. So have a great weekend.
You too. Bye-bye.
Thank you. Bye. Oh, yes, they do count for class hours. Yes, yes, yes.
Okay. All right,
4
good. Then
hours.
okay, so I completed my hours. Then I just need to come in on the 9th for chapters 1. I think I missed like chapters 1, 2, and 3. So I'll be there that week then, and then I'll take the test.
Exactly.
All
Exactly.
right, great. Thank you so much. Happy New Year.
Happy New Year. Bye.
Bye.
Okay, wait, oh, I see what's going on. All right, now I got it.